संस्था कोल्हापूर in 1959 आणि सुसंस्कार यासाठी संस्था is run by the teachers. Dr. Bapuji Salke established Ramakrishna Paramahansa Mahavidyalaya Usmanabad in 1959 to fulfill the need of education in Usmanabad. The first college of the Sanstha, Ramakrishna Paramahansa Mahavidyalaya Usmanabad, is one of the reputed and well-known quality college in Marathwada region. The college is affiliated to Dr. Babasaheb Ambedkar Marathwada University, Aurangabad. The UGC has identified the college as the college with potential for excellence for phase taken. In the last 5 years, our students of our college have received a gold medal in university examination. Ramakrishna Paramahansa Mahavidyalaya is the first and only college for Dr. Babasaheb Ambedkar Marathwada University, Aurangabad, has been selected as a star college under DBT Star College scheme of Department of Science and Technology, Government of India. The scientific concept among the students and faculty members. The college has organized guest lectures of eminent personalities from research and academics, hands-on training programs, faculty training programs, study tours, outreach activities, research projects for students under DBT Star College scheme. With this brief introduction, once again, I welcome you to all. Thank you.
Thank you, sir. Thank you for the welcome address. Now I request Dr. Sambhaji Dhumar sir to introduce our today's resource person. Dr. Sambhaji Dhumar sir.
Good morning, everyone. I am Dr. Sambhaji Dhumar. Pleased to welcome our today's guest, Dr. Bhaskar B. Idge sir, Scientist, Polymer Science and Chemical Engineering Division, CSIR, National Chemical Laboratory, Pune. I feel so honored to introduce such an eminent personality and one of my teachers who has enlightened my life with his excellent teaching and continuous support. Dr. Bhaskar Idge sir has completed his master degree in organic chemistry from Dr. Babasaheb Ambedkar Marathwada University, Aurangabad in 1979. Later on, in 1984, he has earned PhD degree in polymer chemistry from National Chemical Laboratory, Pune. After PhD, he has worked as a visiting scientist during 1992, 1997 to 2000, and 2001 to 2002 in Perkin-Elmer, Switzerland, General Electric Company, Spain, and General Electric Corporate Research and Development Center, New York, USA, respectively. He has also acted as a brain pool scientist during 2005 to 2007 in Korea Research Institute of Chemical Technology, South Korea. His research area has been mainly focused on biodegradable polymers, polymers for controlled drug delivery, polymers recycling, high performance polymers, nanomaterials, optical quality materials, quality management, laboratory safety practices, and intellectual property rights. Dr. Idge sir has published more than 135 research articles in the journals of international repute. On his credit, more than 52 national and international patents, and also he delivered 120 invited talks. Sir has guided 40 MAS, MTech, and PhD students, and also acting as reviewers for several international journals like ACS, RSC, and many more. Sir has received 3 national awards and associated with 10 professional societies. Today, he's going to talk on the subject intellectual property rights in front of us. Therefore, this brief introduction, I kindly request our today's guest speaker, Dr. Bhaskar Idge sir, to deliver informative lecture. Thank you.
Shall I start?
Yes, sir. Yes, sir.
Okay. Good morning to all the participants. First of all, I would like to thank the Professor J.S. Deshmukh, who is the principal of Ramakrishna Paramahansa Mahavidyalaya, Usmanabad. Then Sandeep Deshmukh and then Sambhaji Dhumar for giving me this invitation to share my knowledge and experience in the field of intellectual property right for the benefit of the student, teachers, and the faculty members. So without spending much time, I will start with my talk. My talk is a pictorial talk, and I hope most of the students, they will not find any difficulty in understanding the talk. If you have any difficulty, you can ask me at any time. So today I will be talking on intellectual property right. In short, people they call IPR or IPRs. Since I have worked with different organizations, different multinational companies, and we have developed several products for the benefit of the society, we have filed several patents, and most of the patents, they are licensed to the companies now, and most of the products you can see in the market now. So what is the content of my talk? Today, I will talk about what is meant by intellectual property. Okay, and what are the intellectual property rights, how to protect them, what is TRIPS agreement that I will talk in detail, what is WTO, World Trade Organization, and in detail I will focus on what is meant by intellectual property right and how basically the intellectual property has been evolved over the years. And if the time permits, then I will go to the international convention that is called Patent Cooperation Treaty. This is a world patent, you can say. In the one patent, you can hit about 186 countries. And then we can see what are the IP portfolios. And then I will cover some of the product patents, okay? So what is intellectual property right? From this picture only you can see that the person who thinks out of box thinking, okay, he can generate new ideas, and the new ideas you can convert into intellectual property rights. Most of the times we are having several ideas, but we don't bother. And what happens, we discuss with the friends, colleagues, teachers, and so many places, and they take the advantage of these out of box thinking ideas, but we never convert these into the intellectual property right. So friends, whenever any new idea comes into your mind, first you file an idea disclosure letter, and then you convert that into patent disclosure letter, and then you can contact to any patent attorney who will help you to convert your idea into patent. But for proving that idea, you should have at least one example to show that my idea is working, okay? So I will show some of the famous quotes by the famous patent people or the company people who have filed, who are aggressive in the patent filing areas. Okay, just for the benefit of the students. What is the Peter Drucker says? He says that the test of an innovation, after all, lies not in its novelty, its scientific content, okay, or its cleverness. Only novelty is not important. The scientific content is also important, okay, or its cleverness means how the idea can work. So it lies in its success in the marketplace. Most of the times we are having brilliant ideas that work in the lab, but they fail into the large scale or they fail into the industries. So idea should be in such a way that it should survive in the small scale, in the large scale, and the commercial production. Okay, then only it can go for the patent filing. Then Henry Chesberg says, innovation now, okay, is more of a relay race than a marathon. The pattern of an idea might start at university and move to multiple companies before it is commercial. Idea can come from any corner. Okay, friends, just to tell the example of these Mumbai Dabbawalas. Okay, Mumbai Dabbawalas, they have developed a technique. Okay, how to serve these dabbas on time delivery with the same content, same specific, same time, and they have filed the patent. Okay, so the idea can come from any corner. Okay, each person has an intellect. So how to convert that intellect into products or into materials, that is an art. Okay, so the idea, once you have filed in the form of a patent, that should survive in the commercial scale, then only it works. Most of the times you must have read what is the TRIPS, TRIPS. TRIPS means trade related aspects of intellectual property rights. TRIPS agreement came into being the establishment of when the WTO was formed. WTO means World Trade Organization. It is effective from 1st January 1995. Well, this is the correct definition of intellectual property right. Most of the times people, they misunderstood what is IPR. And this is the actual definition of the IPR. Intellectual property rights itself is defined in the context of the TRIPS, what I told you, as a right given to a people over the creation of their mind. By using your mind, whatever the ideas you have created, and it should be protected by a right as per the TRIPS, and that is called the IPR. It usually gives creator an exclusive right over the use of the creation for a certain period of time. Once you file an idea and you want to go for the production, each patent has some certain life. Okay, maybe 20 years, maybe 22 years, 25 years, it depends on country to country. Okay, suppose I have filed about 56 patents or 56 patents have been granted. I may not do any production, but what I will do, by sitting at home, I will license my intellectual property right to a company, and who can in turn give me the licensing fee, and that is the income, additional income for the inventor. So friends, it is not necessary that once you have filed a patent, that means you have to go for the production. But by sitting at home, you can sell your idea to a company and you can earn the license fee for a certain period of time. So now, since I am having the 56 patents, I have licensed several patents to the multinational companies, and by sitting at home, I am earning in terms of dollars. So that is the strength of a patent. So for the understanding of the students, I have shown here how the IP has been evolved. Once you are having a property, it may be land, it may be house, you have some right, okay, over that property. And once you are having some intellect, you can convert that into property, and then you can protect with a certain right. Once you are having an idea, and you can express it in the form of a copyright. Most of the times, you must have seen some of the products where on the brand it has been written C in the circle. That means that product is copyrighted. Okay, that means legally protected. And once you are having idea, then you can innovate, then you can go for invention, and then you can convert that idea into patent. So mostly my today will be focused on this. Okay, so idea, then quality and identity, you can go for the trademark. Most of the times you must have seen on some of the product names, TM is written, that is trademark. So it goes for idea, quality and identity. Once you are having idea and it has some appearance, then you can go for the design patent, okay? And once you are having idea, and if you want to keep it confidential and no disclosure, that is a trade secret. Most of the times we write some drafts and we forget to write down this is confidential information. Once you don't write at the footnote, then anybody can misuse of your information. But once you have written that this is confidential, then people, they will think that this is legally protected. How it is legally protected? This is legally protected by trade secrets. So friends, always keep in mind, once you are disclosing any confidential information, always write confidential information at the bottom of the draft. So how the intellectual property chain of activities has been evolved? First you create, then you innovate. And once you have innovated, then you go for the commercialization, okay? Once you are going for commercialization and the idea works, then you have to protect it. How you have to protect it? You have to protect in the form of a intellectual property right. It depends on what type of idea it is, what type of innovation it is. Depending on that, you have to protect it. And then you can enforce into the production, into the market, or into the large scale. Okay, these are the IP chain of activities. Always keep in mind, first you create, then innovate, commercialize, then protect and enforce. So if you can see the IP portfolio, once you are having the IP, first it goes for the copyright. Okay, it depends on the idea. And once you are having the industrial property IP rights, then it is divided into these parts. It may be trademark, it may be trade secret, it may be patent, it may be industrial design, it may be confidential information, it may be geographical indication, it may be some know-how, or maybe some reputation. So always keep in mind that these are the two categories, one's copyright and industrial property. So again, IP as an intangible property, okay? What are the different types of property? That is a tangible property and intangible property. Tangible property is a fixed, that means land, house, estate, car. These are the examples of the tangible property. What is the intangible property? Whatever today we are talking, that is intellectual property. Okay, so intangible wealth, easily appropriated and reproduced. Once created, the marginal cost of production is negligible. The IP as an intangible property, you have the economic rights to the creators. Once you have created the intangible property rights, you have the economic rights. Then commercial exploitation of owner of the IP. You can go for the commercial production once you are having your own IP, or you can buy the IP from the other people by paying the license fees. Okay, and whatever the capital expenditure you put on developing that intellectual property, okay, that you can recoup by selling your IP to the companies. Or you can transfer the technology. I am having several patents, but I am not interested because I don't have that capability. So what I will do in that process, I will transfer the technology to a company which is capable of going for the production. Okay, and of course, it is a culture development. Earlier, people were asking how many papers you have, how many publications you have, what are the impact factors. But nowadays, people are asking how many patents you have, and how many patents you have licensed, how many patents, what are the earnings you are getting from the patents. So this is basically nothing but this is a culture development. How to protect, why to protect the IP? Most of the times question has been asked, why to protect the intellectual property? First of all, whatever the expenditure I have put for developing that IP, I should get that money back, okay, by selling that IP. And another thing, the research and development, suppose you want to go for any product development, okay, then you should have your own intellectual property right, or you should have your own IP. And if some people, they have developed the same IP, but they are not interested, then you can buy that IP, okay, and then you can block that window for that company. And third thing is marketing and the advertisement. Suppose you want to market or advertise anything, you should have your own intellectual property right, okay? And once you are having your own IP, there will not be any preloaders, okay? They will not steal your technology, they will not copy your technology, and it is not easy to bring that product into the market. And maintaining the loyal followers, okay? This is very, very important. Once you are having your intellectual property, then it is very easy to maintain the loyal followers who are in the market, who are the people, who are the leaders in that product. And the important thing is the profit, okay? Whatever the profit you are getting by selling or making the product by using your own IP, that is very, very important. IP as a property can be sold. Suppose you are having some patents and if you are not interested, but some company is interested, you can sell those IP. Or you are a big company owner and you want to block the other people, then what people they do, they buy the IP from the small companies and they keep their own licensing on that product. Or you can lease or give on rent. That is also possible. You are having the IP, so you can lease out or you can rent out, or you can pass under a will, like we write a will of your house, of the land, of the property. Similarly, you can pass a will of your intellectual property right, or you can assign your IP, okay, through a legal documentation to certain companies, or to your brother, to your father, or to your sister, to your brother-in-law, or any other company. You can assign your IP by signing the legal documents. Then what is Paris Convention? Okay, that's the international convention. Okay, Paris Convention of Protection of Industrial Property. It came into existence in 1967, but actually came into practice in 1989. Then Berne Convention, you must have heard about that, for the protection of literary and artistic works. Okay, understand these are the different conventions. You should know Paris Convention means for protection of industrial property. Berne Convention means for the protection of literature and artistic works. It came into existence in 1971, but actually came into practice in 1990. Then trade-related aspects, that is the TRIPS agreement. It came into existence in 1994 and actually came into practice in 1995. Then WIPO, World Intellectual Property Organization. The head office is located in Geneva, Switzerland. Okay, they take care of all the international patents. Okay, so WIPO Copyright Treaty, this is basically for the digital agenda. Okay, and the Patent Cooperation Treaty, that is a PCT, you can say that this is a world patent. In the one single patent application, you can hit about 184 countries, okay, so that you can maintain your monopoly of your technology. It came into existence in 2004. So what is Paris Convention? Paris Convention is basically for protection for industrial property, trademark, and patents, unfair competition, which is governed by the domestic legislation. Then Berne Convention, this is basically for protection of literary and artistic work, which is governed by the national legislation. TRIPS, which came into existence in 1994, this is nothing but this is addition to the Paris and the Berne Convention, okay, which has a minimum requirement for the filing of the patents, okay, and which is most favored nation treatment, okay. Then strong enforcement procedure. If you want to enforce your patent application into the market, into the product, then start strong enforcement procedure. Then WIPO, World Intellectual Property Organization, that is copyright treaty. This is basically for digital agenda. They take care of technological measures such as circumvention of technological measures. Then PCT, Patent Cooperation Treaty, if time permits, I will talk on this. This is a world patent. This is making it easier to make a patent application, which is a designated. First, you file a patent application at the PCT, then you can cover about 184 countries in the single window application. Okay. Then international phase to the national phase. First, you file the international patent, and then you go for the national patent filing. So how this IP, that international convention, WIPO, that is World Intellectual Property Organization, which is located in Geneva. This is dedicated for promoting the use and protection of works of the human spirit. Headquarters is located in Geneva, Switzerland. About 184 nations are the members of this WIPO. India is also one of the members of the WIPO. Then what is the responsibility of the WIPO? Manage all the intellectual property rights worldwide. Okay. Then they also organize the training programs for academy and the seminars. Once you go to the Google and type the World Intellectual Property Organization, then you can get all the seminars, all the tutorials, all the procedures of filing the patent. Okay, how to file, what to write, what you should not write, and what is covered and what is not covered. Then I will come that how IP has been evolved. Basically, under the intellectual property right, there are two types. One is the copyright, and second is the industrial property. Okay, copyright goes to right of the author or right of the performer. Okay, then industrial property, again, there are two types. One is information and innovation. Information you can go for the trademark or the geographical indication. Okay. And under innovation, you can go for the patents, then trade secret, and the industrial. Okay. So don't confuse, okay, with this chart. Most of the times people, they misunderstood this chart and they are not able to communicate to the society that actually what is meant by patent and what is meant by trademark, what is meant by trade secret, or what is meant by geographical indication. For that purpose only, I put this flow chart. So we will see now some of the definitions which or the wording which is arising into these intellectual properties. What is intellect? First, we should know what is intellect. It is a mental faculties, the power or the faculty of the mind, which is able to generate the new ideas or the new inventions. What is the power of the faculty of the mind? By which one knows or understands, as distinguished from by which one feels, and that by which one feels. Some words are legal words, but don't worry about that. Which one knows or understands, as distinguished from that by which one feels, and that by which one feels. The understanding, the faculty of thinking and acquiring the knowledge. What is a property which is owned by a person, like we own the land, we own the flat, or we own some house, or we own some car and other properties. Then there are two types of properties, as I told you, tangible and intangible property. So what is the difference between tangible property and intangible property? Tangible means you can see, you can feel or visualize the property, then easy to determine the cost or the value, has no particular term and can be indefinite and permanent intangible. What is intangible? It doesn't have a visible form. It is very difficult to fix the price or the value in terms of IP. Has a particular term, some forms, term can be renewed or maybe extended. So what are the types of intellectual property rights? These are the types. First type is the trade secret. Then second is copyright and related rights. Then industrial designs, trademarks or the brands, then geographical indications, then utility models and the patents, then new varieties of plants or unfair competition. Some of the examples I have shown here. If you find such type of written C above the trade name, that means this is copyrighted material. Okay. These are some of the additional examples, okay, how they are protected legally. You can see some interesting examples like the Kolhapuri chappal, okay, or some different types of designs, toothbrushes, wallets, pens, bottles, and there are several types. The list goes on, different types of shapes of capsules, ampules, syringes, okay, or maybe bottles or the medicine shapes. Then this list goes on. You can see some of the ornaments, cloths, designs, okay, jewelries, okay, and the list is too big. So what is, there is a one term that is a quasi-intellectual property rights. There is another term that is quasi-IPR. It comes for data exclusivity, then brand loyalty or the goodwill, house name, client or the customer list, market intelligence, or test methods. Then in-house standards and the specs which you have developed. Then management practices, different management practices which are followed in different offices. They are coming under quasi-IPR. Once you are writing confidential information in your draft, that becomes a type of quasi-IPR. Some know-how which you have developed and you don't want to disclose, then it comes under this quasi-IPR. Or some reputations or some impurity profile, suppose you have developed for a certain compound and that you don't want to disclose and you want to protect by IP, then it is a type of quasi-IPR. So IPR and quasi-IPR, these are the differences. Patents, trademarks, designs, copyrights, and others. These are the types of the intellectual property right. And quasi-IPR, confidential information, some know-how, trade secrets, and some reputations. The list goes on. Geographical indications, CPD, EPOE, IC layouts, related rights, neighboring rights, domain names, data exclusivity, brand royalty or goodwill, house name, then client or the customer list, then market intelligence, test methods, in-house standards and specs, impurity profiles, and some management practices. So we will see now one by one the different IPR types. First, I will start with trademark or a brand. Okay, trademark is a sign capable of distinguishing the goods or services of one enterprise from those of the other enterprise. Okay, that comes under the trademark. Trademarks are protected by intellectual property rights. Once you see some products and on the brand name, it is written as TM. That means it is protected by a trademark or a brand. So these are some of the famous examples which are protected by the trademark. This is McDonald's, Reliance, Intel, Surf, MasterCard, Tata. Okay, or this is our CSIR trademark. Okay, this is ICICI Bank, then Airtel, Coca-Cola, Mercedes-Benz, and several. The list goes on. It's a big list. Okay, so TRIPS. This trademark is protected by the TRIPS agreement, Part 2, Section 2, Art 15 to 21. This is nothing but this is basically a word mark, device mark, which is a sign, symbol, or some logos, is a collective marks, certification marks, and the service marks. If you see such time on any brand name or the product name, that means it is protected by the trademark. Like must be graphically represented, must be distinguished and distinguishable, must not be descriptive, it should not be descriptive, must not be deceptively similar to the known or the well-known marks. You're not supposed to generate the trademark which is already known in the market. Okay, it should be different, it should be new, it should have some novelty. Okay, like some antibiotics or the medicines, fusimide, it contains the lacimix or the fuchimix. Same is the case with cefixime, GP, CP, or cefixime. Okay, please avoid geographical indications, deities, national leaders, heroes, symbols, and laudatory words when you define a trademark. Okay, always keep in mind this should not be there in your list. Then there are some pharmaceutical examples in the trademark. Okay, while proceeding for marketing approval, had a question. Okay, while choosing brand names, there is a famous case study. If you go to the Google and read Zydus Cadila versus the Sun Pharma. Okay, there is a trademark violation suit of an antidepressant drug, Vance OD of Zydus versus Venixexar of Sun Pharma. This is a famous case study on violation of trademark, okay, which is available on the Google. You can read it just to understand how the trademark is violated. The active ingredient basically in both the cases is venlafaxine. Okay, this is antibiotics which is common in both the drugs. Okay, but there is a violation, okay, of the trademark. Then you must have seen the ball pen. Okay, there is a famous case recently of trademark violation. There is a Mont Blanc company which has manufactured the ball pen. Okay, on that ball pen, they have started putting the Gandhiji's image. Okay, and they have violated the trademark. Then what is copyright? Once you see such type of sign any on brand or any name, that means it is protected by copyright according to the TRIPS agreement part 2 section 1 art 9 to 14. So copyright is nothing but is a legal term describing right given to creator for their literary and artistic work. If there is any literary or any artistic work you want to bring into the market and you want to protect your monopoly, then you can go for the copyright. Okay, you must have seen most of the novels people they write and they take the copyright, or the books. Okay, they become the examples of the copyright. Then what is covered by the copyright? This is a big list. Okay, the kind of works covered by the copyright include literary works like novels, poems, plays, reference works, newspapers, computer programs, databases, films, musical compositions, choreography, or artistic works like painting, drawing, photographs, or some sculptures, or some architecture, if you develop, it becomes a copyright, some advertisements, maps, or some technical drawings. So the list goes on. So copyright is extended again, IT revolution also, some recordings, broadcastings, audio visual works, computer programs, digital databases, internet or the web, cable and the satellite TV, okay? And recently, Amitabh Bachchan to copyright his voice. So IPR and copyright, what is the commonality in this? Quoting medical references from journals and the books. Suppose you want to protect your writing material, okay, then you should write this type of wording or this type of sentences below your write-up. Copyright, all right reserved. Don't use, reprint, reproduce, or distribute without prior permission. If you write such type of 2 lines on your draft at the bottom, then it is legally protected. If somebody is copying your material and reproducing and using for his own purpose or circulating to the society, okay, then you can sue him into the court of law, okay? But if you don't write this type of wording below your draft, then it is not legally protected, okay? So avoid the verbatim reproduction likely to cause copyright violations. Always acknowledge, obtain prior permission. If you are copying somebody's material, okay, you can always acknowledge, okay, for your help or for the permission. And you can ask him, can I copy your slides and use for my personal use? Take the permission from the author who is presenting or who has prepared the draft or who is presenting in the lectures or the seminars. Then abstract on summary may be written to one's own language and quote the source. Always, if you are taking somebody's material for your personal use, take his permission and write that this is for my personal use. Okay, this is not for commercial use. And if you violate the copyright violations, could lead to the criminal or the civil suits. And there are famous cases, people, they violate the copyrights, okay? They copy the information, use the information without the prior permission of the company or the author, okay? This could lead to the imprisonment also. So beware of the web domain in the new global regime, okay? Use of internet for selling and marketing, okay? Downloading from internet. Suppose you want to download somebody's content from the internet, you have to take the permission from him, okay? Because you are downloading this material for your personal use, for office use, or for commercial use. You have to inform him, you have to take the permission. Whatever the downloading you are doing from the internet, each and everything is recorded in the Google. Okay, Google knows this and this person on this and this date, on such and such time, he has downloaded this much thing. Okay, and this information goes to the concerned person or the concerned company. And if you don't take the permission from that company or from that person, then they can sue you into the court of law. So they must always honor IPR, copyright, patents, etc. So recent copyright cases are maybe Chetan Bhagat versus the Three Idiots. This is a famous case. If you're interested, you can read from the Google. October 2010, Kolkata High Court declared that Saregamapa has the right to grant the license. And in April 2010, Kolkata High Court restrains the use of the song Apni To Jaisi Taisi from Lawaris in the movie Houseful. So such type of famous examples, such type of famous cases, they are available, okay, on the copyright cases. So distinction and degree of protection, how to protect the copyright. Basically, if you want to express any idea, you can take these. Then protection is specific and its protection scope is fairly narrow. Okay? Suppose you want to protect your idea in terms of copyright, protection is very, very narrow. You have to convert that idea into the product and then you can go for the filing of a patent. Okay? The patent, if you are having a novel idea itself, when applied and useful, can cover a relatively broader scope, including various applications or programs, or broad protection, including equivalence, you can go for the patent. Then there are other examples of pharmaceuticals in the Design Act. So these are the size, shape, color, etc. which are protected by this US patent granted to Merck. You can see this, and there is a pharmaceutical in the Copyright Act. If you want to make some insert or the information leaflet, okay, you can go for the copyright so that other person, other company will not copy your content and they will not make use for their personal use or maybe company use. A geographical indication, that is GI, they call GI. It is an indication. It originates from a definite geographical territory. Okay, it is used to identify agricultural, natural, or the manufacturing goods. Then the manufactured goods should be produced or processed or prepared in the same territory. It should have a specific quality, special quality or reputation or other characteristics. Who is playing with the screen? Somebody has put some mark. So geographical indication of goods are identified as the aspects of intellectual property, which is referred to the geographical indication, referring to a country or to a place situated where it being the country or the place of the origin. Typically, such a name conveys the assurance of quality or the distinctiveness which is essentially attributable to the fact of its origin that is defined by the geographical indication of that region or the country, which is covered by the TRIPS Agreement Part 2, Section 3, Art 22 to 24. Then, geographical indication, India is a member of WTO, okay? Enacted the Geographical Indication of Goods Registration and Protection Act 1999 has come into force with effect from 15 September 2003. Geographical Indication of Goods Registration and Protection Act came into force 1999. Then Registration and Protection Act for the Geographical Indication Goods rules came into force into 2002. So these are some of the interesting examples of the geographical indication. You must have read about the story of Basmati rice, then Darjeeling tea, then Kanchipuram silk, Alfonso mango, okay, which is coming from Maharashtra, okay, that is protected by geographical indication. Again, the Nagpur orange, then Kolhapuri chappal, then Bikaneri bhujia, Agra peta, Goa feni, Lonavala chikki, Nevara rice. There are several examples, okay, which are protected by the geographical indication, okay, and because of this, they could able to export this material to the outside countries. This is a famous example, okay. This is a famous example of Tirupati Laddu. You, most of the people must have visited Tirupati and you must have seen that they give the prasad as a Tirupati Laddu, and Tirupati Laddu is a best example of geographical indication. That Laddu got the geographical indication legally and it is legally protected. October 2010, rectification petition filed with the GI registry. Then in June 2010, Madras High Court dismissed the petition on the grounds that the already alternate remedy of rectification under the GI Act has not been exhausted. October 2009, PIL filed by Mohan Raj in Madras High Court challenging the grant of GI for the Tirupati Laddu. And September 2009, GI granted to Tirumala Tirupati Devasthans. Then we will see what is meant by trade secret. A trade secret is nothing but is a formula, is a practice, process, design, instrument, pattern, or compilation of information. The best example of trade secret is Coca-Cola. Okay, Coca-Cola is protected under the trade secret formula. Okay, so which is not generally known or reasonable ascertainable by which a business can obtain an economic advantage over competitors or the customers. In some jurisdictions, such secrets are referred as confidential information, okay, or classified information. Okay, if you write such type of wording on your draft at the bottom, that means it is legally protected under the trade secret. These are some of the examples. Okay, a formula for a sports drink, a survey methods used by the professional pollsters, different recipes which we make, and it gives a suitable taste, a new invention for which a patent application has not yet been filed. Suppose you have not filed the patent application and you are hurry in protecting those information, then you can go for the trade secret. Okay, or different marketing strategies, and then manufacturing techniques or some computer algorithms. Then there are additional examples, okay, like the Coca-Cola, formula for Coca-Cola, the Big Mac special sauce which you get in the Mac, okay, that is protected by trade secret. It has a specific taste which nobody can repeat it, okay, or the KFC chicken recipe, okay, it has a specific taste, okay, specific ingredient, or WD-40 formula. So such products are protected by the trade secrets. So in one slide, I have tried to show you how the intellectual property of one product you can assign. This is nothing but, this is a multi-inhaler, which is prepared by the Cipla, and which is protected by trademark, design, trade secret, copyright, and a patent. Okay. So how it is protected? Trademark, multi-inhaler, okay. TM, that is Arm Bill 2009, passed by the Rajya Sabha on August 10, 2010. So it is protected according to that. Then external appearance, it is protected by this design patent number this. Then trade secret know-how, it is protected by confidential information and undisclosed technology. Then copyright, it is protected by the package insert which they have prepared, they have printed for this product, okay, or the information leaflet, okay. And the patent they got for this product depending on the novelty and the inventive step. So they got this, they got the US patent, US 7395821, based on all these novelties. So if you can see the scenario, how the product patent has been evolved in India, okay. In 1972, after 23 years in 1995, we were aware of about the filing patent information. Then after that, after 10 years, we are aware and we know how to file a patent, what to file a patent, where to file a patent, and we were very aggressive in filing a patent. But till that time, we were very much interested, okay, in going for publication or presenting the data in the different conferences, different things, and people, they were misusing your data, okay, and then they are taking that information and making the products and going for the production, okay. So like this has been evolved, end of the product patent era, and the reverse engineering from this beginning of the product patent era started, then return to this era again. So this is the story behind the product patents in India, okay. Then how it has been evolved from now, from GATT, then we went for WTO, World Trade Organization, then we went for TRIPS agreement, and then we are in the field of IP amendments. So we evolve from here to here, and then we are here now, okay. How this has happened? Because of innovations, different innovations. First, initial incremental innovations, then need-based solutions, then intensive research, disruptive inventions, and then serendipity. So this is basically, this has been evolved. So like this, IP has been evolved. So you can see in the one slide, this we evolved from here to here, and now we are going from here to here, and now you can see that you are getting these mobiles and these with a very, very specific combination of information, data, security, and all those things. Now I will cover what is patent, what are the different patent procedures, and what is patent cooperation treaty. This is my second part of my talk. How long I can continue? So what we'll see, what is a patent, what is patentable. You should know what is patentable and what is not patentable. The specific drafting. Suppose you have done some work and you want to file a patent, how to file the specifications. Okay. what are the contents of the specification, and especially the claim drafting. The first claim is a very, very important claim. How to draft the first claim is very, very important. Then how to interpret the claims. And once you file a patent, what are the examination procedures, how this goes from one place to other place till its publication. And then in the last part, I will cover what is patent cooperation treaty, that is the world patent, and then Budapest patent. So what is a patent? A patent is a form of intellectual property, which is a creation of the human mind that is protected by a law in a fashion similar to real property. Like you protect your land, like you protect your piece of land, house, or any other property. Similarly, your intellectual property is protected by a law that is called intellectual property right. So it is basically a limited monopoly. Each patent has a limited time period. After that, the patent gets lapsed and the information becomes open. It is limited monopoly right conferred by the country in consideration of disclosure of the invention. Like you can see the game between the Steers and the Rogers. Okay, this is only the name of the wording game. Okay, so you can go for the intellectual property right. What is the latest patent confers? Is the right to exclude others from exploiting or using the patent. Suppose I am having today some number of patents, X number of patents. I will not go for the productions, but I will restrict others who are interested to make this product by using my information. And suppose they want to go for the production using my information, then in that process, what I will ask them, you pay me some XYZ license fee, maybe in terms of depending on the country, which country it is, in that currency. So by sitting at home, by selling the information, I can earn the money. Okay. So legal, what is the legal definition of a patent? It is basically a property right granted by the government to an inventor to exclude others from making, using, offering for sale, or selling the invention or importing the invention. Okay, you understand these wordings. Who is putting the red line, blue line on the screen? Would you please tell me? Hello? Hello?
Don't do this. Some students are doing this.
This is very annoying. This is very annoying. I get annoyed with this.
These controls are not in our hand.
You stop that fellow who is doing such type of silly things. This is an insult to the guest. The patent is a right, property right granted by the government to an inventor to exclude others from making, using, offering for sale, or selling the invention or importing the invention for a limited time or exchange of information to the public disclosure. Each patent has a certain time period. After that time period, your patent gets lapsed and the information becomes open to the public. A common misperception of the patent is patents inhibit the free exchange of information. This is basically a legal document issued by the patent office, granted for a limited period, confined within the geographical limit of the country. Each country has the certain time limit for the each patent. Okay, after that the patent gets lapsed. Okay, confers a right to exclude others. You are having some information, you are having some patents, you will not go for any production or will not use it, but in that process you can sell the information to the other companies and then you can earn, okay, the money in the different exchange rate. It is basically a conditional grant, the balance of right and obligations subject to like other laws of land, then granted to owner of the invention and the assignee. Patent is not a right to perform the invention or a monopoly in the marketplace. Please understand this. Patent right is not a right to perform the invention or monopoly in the marketplace. You require patent protection if you want to go for the progress of technology, for the progress of research in the field of technology, to encourage the inventive and the creative minds, and feel secure and contribute continuously to convert intellectual capabilities and outcome from the property. Like the place National Chemical Laboratory, we encourage our students. Suppose a student is filing a patent, then he has been given some award and he has been given some research grant, okay, for that financial year to perform his research. This type of encouragement we give to the inventors who are filing the patents. Patent is a prestigious. Always you will say that, oh, I am having X number of patents, and you will always say that, oh, I did it. And always I will say that I was the first person to file the patent in this area. This is very, very important. I was the first. Easy publication, there are no editors. If you send a publication for a journal, there will be at least two editors, one editor, and there will be two referees. Okay. So unless and until he get the reports from the referees, the editor cannot take the decision. Similarly, it is not for the patents. Patent has one patent attorney or the patent agent. It will go to him, and then he will read the patent. He will ask some queries, and then your patent get published. And once the patent get published, you can license to the companies who are interested, and then you can, during that licensing, you can recoup whatever the expenditure you have put in developing that information in research and development. And not only that, once you are selling your patents to international companies, then you get the expanded collaborations. This is very, very important. Okay. You are known internationally that such and such person is working on such and such product, and they will be behind you to, okay, to license your patent. Then commercial advantage over the competitors. Always there will be commercial advantages. If a competitor has developed something and if your patent is more advantageous as compared to the earlier information, okay, then you can earn more. Then provide valuable trading assets to help assure the freedom to practice or freedom to operate. Freedom to operate and freedom to practice, these are the two wordings. They are very, very important in terms of intellectual property rights. So what is a patent right? Basically, a patent is a grant by the government that entitles the owner, okay, to exclude others, okay, from making, using, selling, or offering to sell or import into the country a patented invention. A domestic patent only provides these inclusive rights in the country. A patent does not necessarily give the owner the right to practice the patent because of the other's potential prior patent rights. Suppose somebody is working in the same area. So what these companies do, they will buy the patents from these 2 or 3 people, and they will block them, and they will maintain their monopoly by paying some royalty or paying some license fees to these inventors. Always you should be the first to file the India, the person who is filing first, that credit goes to him. So always first to file system is used for filing the Indian patents. So if you see this, the patent office scenario, Controller General of Patents, Science and Trademarks, you see the office scenario here. Patent office, head office is in Kolkata, okay. Then design office is in Kolkata, okay. Then there are branch offices in Delhi, Chennai, and Mumbai, okay. There is a IPTI NIPM office is located in Nagpur. They conduct the trainings on intellectual property right. If somebody is interested to participate into this, you can register with their office and you can attend the training. If you want to become a patent attorney, a patent agent, or an inventor, you can attend their programs. Then there is a trademark registry. Head office is in Mumbai. Then other offices are Delhi, Kolkata, Chennai, and Aurangabad. Okay. Then GI registry office is located in Chennai. Then there is a Controller General. Below this, there is a Joint Controller, Deputy Controller, and Assistant Controller. And there are examiners who are highly qualified people. They are doctorate degree holders in the specific areas. Okay, they can become the patent agents. Okay, there are patent examiners who will examine your scientific content before assigning the patent. So what is the old definition and new definition of invention? You must know what is invention. Invention means any new and useful art, process, method, or manner of manufacture, machine, apparatus, or other article, substance produced by manufacturer and includes any new and useful improvement of any of them are like this thing. And the new definition is very simple. Invention means a new product or process involving an inventive step and capable of industrial production or industrial application. Suppose you are having an invention, it should have some new inventive steps, and of course, it should be survive at the industrial production or industrial application. According to section 21J, invention means it is a new product or a process involving an inventive step which is capable of industrial application. This is called invention. Okay. So what is patentable? Diamond V. Chakravarti in his US patent, he says that anything, okay, under the sun that is made by a man, that is patentable. Okay. Patent is nothing but is a solution or the invention which is gives some certain application which satisfies the condition, okay, that is patentable. So you should know what is patentable and what is not patentable. The invention must relate to a process or product or both. It should have some new and a novel step, inventive step. It should go for industrial application and not fall under section 3 and section 4 of the patent law. Then new, what is meant by new? Invention must not be published in the India or elsewhere. Once you publish, then you cannot patent, friends. But once you patent, then you can go for publication. Okay. Always keep in mind, if there are some inventive step and which is useful for doing some application, industrial application, then first you file a patent application, and then after certain time, once it is filed, then you can go for publication. But you cannot go revert back. Once you publish, then you cannot patent. In the prior public knowledge or the prior public use in India, claim before in any specification in India. So always see the precautions. Okay, invention must not be published in India or elsewhere. What is inventive step? This is very, very important. You must understand what is the inventive step. A feature of an invention that involves what is the technical advantage as compared to existing knowledge. Suppose somebody has filed a patent and he is getting yield about 46, 47%. And I also prepared the same material by changing the condition, changing the catalyst, changing the procedure, and I'm getting 99%, then you can also file a patent. Okay. This comes under technical advantage over the existing knowledge, or having an economic significance or the both, and makes the invention not obvious to a person in the scale, which is obvious, okay, by according to the laws, that you cannot patent it. So requirements for the patentability, this is a very, very important slide. You should know usefulness, you should know novelty, you should know non-obviousness. What is useful means? Must have some utility. Whatever the patent you have filed, whatever the products you have mentioned in your patent, it should have some utility in the marketplace. Okay. And which is to be achieved by some objective. There should be some objective in making this product. Okay. And of course, it should not be against the public policy. You cannot make or a process or a product, okay, without following the public policy. It should be novel, must be new, must be different from the prior art. Prior art means earlier people, what they have reported, what they have patented, it should not be, it should be totally different from that. And non-obviousness, that is subject matter as a whole, would not have been obvious at the time of a person of the ordinary skill in the art. So always keep in mind, your invention must be useful, it should have some novelty, and it should be non-obviousness. So what is the invention? And ask this question before drafting a patent. What is my invention? Is my invention patentable? Answer those questions. Is invention has a novelty or inventive step? What is my prior art, which earlier people they have reported? Maybe oral disclosure, maybe printed disclosure in the form of publications or the patents. Okay. And what is the prior public use? So before drafting, conduct a literature search. This is very, very important. Most of the times, whenever I ask to the student while conducting the PhD Viva, how you have conducted the literature search, and he will tell me, sir, I have used the Google Scholar or Google search engine. Friends, Google is not a proper search engine. It is a free search engine. You can miss some of the information which is very, very important to your topic. So follow the proper search engines. Which is the proper search engine? You can go for the chemical abstracts, or you can go for the SciFinder search. SciFinder search is from the American Chemical Society. If you want to conduct your research and if you are doing some literature search, use SciFinder. Okay, SciFinder is a literature search engine which will give you till the last minute search query in your area. Okay, enlist the problems in the prior art. Okay, and if you are having the SciFinder, using the SciFinder, there is a term called panorama. You can generate the panorama and it will tell you where are the blanks, where there is a scope for doing the research in this topic or on this topic. Okay, this will help you, okay, to get some new ideas in that area. Okay, what is the problem sought to be solved by my invention? What is the novelty of my invention? What is the solution which I am searching is obvious? Is it artificially excluded? Has the publication ensued? And ascertain the type of application, whether it is a complete or the provisional. First, you have to file the provisional application, and then you can file for the complete application. Decide the area and the nature of protection, Paris Convention, PCT, or the ordinary application. Since you are a citizen of India, first you file the Indian patent application. And if you are interested to go for the world patent, then you can go for the PCT application. Which is not what is not patentable. You should know what is patentable, what is not patentable. Inventions that cannot be patentable are frivolous inventions that you cannot patent it, or contrary to well-established natural laws that you cannot patent it, contrary to morality or injurious to public health, like animals, plants, or to the environment, you cannot patent it, or the scientific principle or abstract theory, you cannot patent it. New property or use of a known substance that you cannot patent it. Mere admixtures as opposed in the synergist mixtures and process thereof, you cannot patent it. Or mere arrangement or rearrangement of the known devices, okay, each functioning independently of the another, that you cannot. So there is a big list what is not patentable. Okay. Method of agriculture or horticulture, treatment of human being animals, including diagnostic methods, plants and animals in the whole or part thereof, essential biological processes, mathematical or the business methods, computer programs, literary, dramatic, artistic work, method of playing games, or presentation of information. What is public knowledge and what is common general knowledge? A known to persons in the part of the mental equipment of those concerned in the art under consideration. And what is general knowledge? All available public knowledge that is published in the literature. What are the kind of publications? Papers or publications should provide mistake the direction or disclosure. Even a single disclosure is sufficient to the extent of publication availability. So who reads your patent application? It is read first by the patent office, the licensee or assignee. Okay. Who is the assignee of your patent? He reads, or the licensee who is interested. Court of law, the technical peers or the skilled persons, your competitors, they will read daily what are the new patents coming in this area, or the commercial players in the general public. So what type of applications are filed? First, you file a provisional and the complete. Kinds of applications, conventional or the Paris PCT, non-conventional, divisional, and the patent application. Okay, what is a provisional specification? It covers when there is an urgency. Suppose a student want to leave the organization or he want to submit the thesis. In that case, you can go for the provisional filing patent application. Or you want to go for commercial production, where there is a need of protecting the information in such cases, or submission of thesis, or inventors leaving the company, or it is accidental disclosure. Suppose you are doing something and you got something different, okay, which is a source of patenting. Then in that case, you can go for the patent. Or there are many competitors who are working on the same product, okay. In that case, you are in a hurry, then you can go for the provisional patent application. Then provisional patent application basically is a document describing the invention and the need not contain the claim. Claim is not important here. Application is very, very important. Okay, disclose as much as possible about your research, about your work, about your technology. Decide the date of application. Date of filing is very, very important. Suppose your friend, your competitor is filing the application on the same problem, and whoever has filed the first, the claim goes to the person who has filed the first. Okay. Then, if you are interested to file the patent, there are different forms which are available on the website. There is a form 2. You have to fill this form 2. The following specification describes the invention. Such type of wording you have to use while filling the form. Then specification can be amended within a 12 months time period. Okay, you can change, delete, add any information in the patent draft. Okay, by postponing maximum to 6 months, but after that, once it is complete, then you are not supposed to change any information, add or delete any information. Then after that, you can go for the complete patent filing. Is a techno-legal document describing, specifically claiming the invention. Form 2, you have to use this type of wording. The following specification particularly describes and ascertains the nature of the invention and the manner in which it is to be performed. Basically, you should be clever in writing the patent draft, but that you can learn by practice. Okay, nobody is born with this art, so you can learn by practice how to write the form 2, what information is to be written. Then patent specification again, there is a description. There is a description and the claims. Okay, description discusses the invention and the claims define the boundary of the monopoly. So what is a complete specification? According to section 10.4, specification shall fully and particularly describe the invention and its operation or use and the method in which it is to be performed. Okay, discloses the best method of performing the invention which is known to the applicant for which it is entitled. So description of the patent, it must describe the invention comprehensively. It should fully explain the problem to be solved with some examples. There should not be any ambiguity whenever you are writing the description. It should be adequate and specific so as to learn the enables the art. The reflect that invention must be novel. It should have the inventive step and there should be industrial applicability. Okay, that is patentable under the Indian patent law. What is the content of a patent? Then it should cover the title, field of invention, background of invention, prior art details, object of invention, statement of invention, and detailed description of invention. So title should be a concise statement, providing the crux of the invention. Care should be taken to incorporate all major aspects claimed. It should go, whether it is going for product, process, or the apparatus. For example, like brush, for brush, you can write cleaning articles. So you can cover all the cleaning articles, including the brush, okay, which is used. Such type of wording you have to use while writing the examples. Write pen, don't write the pen, write the writing instrument. So all the instruments which are used for writing, including the pen, they are covered. The field of invention, more details than the title, you should give it. Provides utility, always give the utility. What is the utility of the material or the product? Okay, sometimes used as a tool for search with the absence of the abstract. Provide the technical background of the invention. Give the background in the detail. Then prior art search, as I told you, use clever search engines like SciFinder and you see that what is reported, what is not reported. Okay, this will tell you about what are the blanks, where are the blanks, where you can focus your research. Okay, and once you are having the prior art, then you should know something is missing somewhere and that becomes a part of the invention. This is my literature search and something is missing, some information is still missing on the same problem. So you can attack on that problem and that becomes a step for your invention. So prior art, again, you answer what are the unsolved problems. What is the prior art solution not working? Most of the times prior art is given, but it doesn't work. describe the new solution adequately. And suppose if you have developed some new strategy or new procedure, new technique, you describe that, okay, fully. Then provide the purpose of the invention. What is the object of the invention? It will provide the purpose. What is the purpose? Why this invention has been carried out? What are the main objects and the ancillary objects? What are the essential aspects and the preferred optional aspects? Then chemical invention, basically statement of invention, it forms the main claim or the claims in the verbal agreement. It is essential only when there is an omnibus claims. Detailed description, set out the best mode of performing the invention, give the detailed description, describe the invention in a greater detail with different examples, give some graphs, tables, diagrams, illustrations, etc. Describe sufficient to enable in the skilled person to put the invention into practice. Claim, the first claim is the very, very important claim. The main claim defines the essential features and the sub-claims and also defines the preferred optional additional features. The important main properties need not be merged into the another claim. A separate claim has to be formed for the important features. Is the operative part of the specification. Claim is very, very important. By reading the claim, people, they will license your patent. Define the monopoly to be conferred by the patent. Define the metes and bounds of the invention at the time of infringement. Okay, proceeding only claims will be done. If you don't claim properly, then your invention will be disclaimed. Okay, what are the do's and don'ts of the invention? Generic expressions should be substantiated or supported properly. The names, terms used should be familiar to the person in the skilled art. The newly coined terms like names should be clearly described. The specification must describe the invention concisely. It should explain the problem solved with full examples. There should not be any ambiguity once you are writing the patent. It should be adequate and sufficient so as to enable in the art to perform the invention. Chemical invention, substance per se, give the broad coverage. Substance can be defined in terms of give the nomenclature, general formula, structural formula, its constituents, then properties or constructional and the structural features used, etc. Give all the information about the substance to cover the broad coverage. Product per se, use the composition synergy, second generation product enhanced efficacy, describe the essential ingredients of product in the composition, give the different ratios, percentage of the ingredients which you have tried, use, their effective amounts, any optional or the additional ingredients. There is process, give the starting materials clearly, give the different steps, how the invention was performed, various parameters like time, temperature, catalyst concentration, give the complete details, give the end product. Give the proportions, always write the broad proportion. Okay, suppose you have used catalyst some 0.1%. So, okay, define from 0.001 to maybe 2% or 5%. So give a workable range. Okay, unless an exact amount is crucible. Then specify the class and specific chemicals used. Okay, all the oxidants like such type of wording, all the oxidants that would enable the intervention, all alkali or the acids that would help to work the invention. Then fundamental research like PCR techniques, use specifications to describe the general art, approaches adopted, detail enabling process, and the best mode of performing the operation. Avoid negative examples. Okay, what's difference in the IC50 values of anti-cancer drug with two different hosts? Such type of examples. Like an anti-cancer drug effective against and subject may not be providing the similar result with the subject to another genus. Okay, independently worded claims, very easy to understand the invention, easy to search, easy to license, and easy to establish the infringement. So characterization of claims is not possible in many cases and need not be characterized. Even if it is characterized, subclaims need not be restricted or characterized part. What is infringement? Most of the times you must have heard this word. What is infringement? Infringement of a patent occurs when a competitor makes, uses, sells, offers to sell or imports an embodiment of the invention without the permission of the patent owner. Most of the times the information has been misused. Okay, they try to copy the information of the another inventor and make the product and put into the practice. In that time, the patent infringement occurs. Okay. How the patent infringement occurs, you can see here. Okay, this is basically my broad area. This is my broad claim. This is infringing embodiment, which is lying inside this, and which is lying outside, that is a non-infringing embodiment. Okay. So primary infringement, who does or who causes making the product. Secondary infringement, commercial activities, selling, distribution for sale. Okay. Sales, that is for hire or by the way of trade exposures or offer for sale to hire or any infringing copies. Distribute infringing copies or importing to Malaysia. What is infringement? The type of remedies for infringement are, there will be, you have to pay the fees in terms of the different currencies. There are a lot of damages if you do the infringement or the injunction stopped by the infringer. Okay. So what is patent infringement? Patent only cover those products or processes described by the claims. An infringing product or the product process must have each element of the claim. Okay. Then the infringement will occur. The accused product or the process may have more than required by the claim. Then how to test the patent infringement? Okay. Determine the meaning of the claim construction. Apply meaning to the accused device. Okay. The literal infringement and the doctrine or the equivalent infringement. So checklist before filing a patent, conduct a literature search properly. Is the patent invention patentable? Answer these questions. Has it been published? Okay, ascertain whether it is a complete or a provisional is to be filed. Initially, you have to file the provisional patent, then it goes for the complete patent filing. Analyze the problems in the prior art. What are the problems? There is no solution, and you found some solution for that. What is the problem sought to be solved by my invention? Is the solution obvious? And what are the non-patentable items? Okay. And specific Indian requirements, especially for microorganisms, see the deposition, source, origin, etc. Collect all the details, experimental data, example tables, graphs, and draft the text. Once it is ready, then patent filing process starts. Okay, filing of patent application. Once it is a filing provisional, okay, then complete publication of application. I have shown here the timelines. Then request for examination. Then you get the first examination report and the patent gets granted. Okay. And then within 12 months, decision of the controller comes. If you want to go for the appellate board, you can go to the appellate board if you're having some queries about your patent. Then once it is filed, then it goes through this process, patent filing, request for examination, first examination report, 12 months, the response, the discussion, hearing, and acceptance. So these are the steps from filing to the acceptance of a patent. Once you file a patent, you get a step of report from a patent office, and they will highlight the queries related to your patent. Okay. And they will highlight some of the queries related to your objections of your claims and the writings that you have to reply to these queries within a certain period of time. The patent attorney will highlight such type of queries. Okay, then you have to reply to that. Okay. Then stat and strips. These are some of the, then ISR report or IPER report will get from the patent office. Then seek hearing 10 before. These are the legal procedures. Once patent goes for filing and there are some queries from the patent office, then you have to reply to these queries. Okay. Then if there is a time, then I can cover the PCT application. How much time is there?
15 minutes, sir.
Okay. So shall I cover the word patent application?
Yes, sir.
Okay. So now I will switch over to the second part of my talk, that is the patent cooperation treaty. How the PCT has been filed. First, we will see that what is WIPO Convention, World Intellectual Property Organization. As I told you, the head office is located in Geneva, Switzerland. So WIPO Convention was signed in 1967 and enforced in 1970. So in 1974, WIPO becomes an UN agency. WIPO was born from the merging of the Paris and the Bern Convention. Okay, these two conventions were merged and WIPO has come out. What are the objectives of the WIPO? Promote IP protection worldwide. Okay, in a single window application, you can hit about 184 countries to ensure administrative and cooperative among the union establishment by the WIPO. So what are the objectives of the WIPO? Basically normative activities, then program activities, international classification and standardization activities, and registration activities. All these, they are taken care of by the WIPO. And the head office is located in Geneva, Switzerland. So how does the PCT system look like? PCT means Patent Cooperation Treaty. Okay. What is PCT? We'll see what are the uses of PCT, what are the advantage of PCT, and what are the PCT developments. Okay. So what is PCT? Procedural international treaty facilitating certain steps in the process of obtaining international patents. It establishes a process for filing and processing of a single application for a patent which has a legal effect in the countries which are treaty members. India is also one of the members of the treaty. It simplifies the procedure for obtaining the patent protection in many countries, making it more efficient, okay, and economical for patent system users and the patent offices. Then decision or granting patent is made exclusively by national or the regional offices in national phase, signed in 1970 in Washington, DC, and became the operational in June 1978 and with 18 states. And there are now 184 countries. The PCT now has, this is old, so now there are 184 contracting states or the members. So PCT allows for simultaneous patent application in all PCT states. PCT regulates requirement of application. PCT response to application consists of international search report. Once you file a patent, then you get the ISR, that is called international search report, and the written opinion of the patent attorneys. Okay. Then publication of application and search report with the IPO office, you will get it. The national patent application are paid. The supplying translation of the application in the national piece. Only friends, you have to keep in mind that if you want to file the international patent application, you have to bother with the fees. Fees is very high. It is about 1 lakh rupees. Okay, that is the patent application fee. So why PCT? For protection in the multiple countries. In a single window application, you can hit several countries. The patent has an inherent merit. PCT is the owner. If you are having one PCT application, you will proudly say that, oh, I am having 10 PCTs, 20 PCTs, or maybe 25 PCTs. So you will be the proud owner of the PCT. PC is basically not any people, they sometimes call the international patent. Actually, this is a patent cooperation treaty. PCT is a window through which an applicant can file a single patent application and secure priority in the designated states. Okay. Then search report, evaluate the invention, and then you will get the examination report. This is the toolkit of the PCT, patentability analysis, harmonized formalities, global reach, flexibility, electronic filing, buys time, and protect against the errors. So these are the advantages of the PCT. So once you file a single PCT application, simultaneously application has been filed in 184 countries. Then once it is filed, then it can goes for the designated national patent office and then PCT headquarters in Geneva. These are the steps. Filing of priority founding application 12 months, filing an international application 6 months, search report, then amendment response 16 months, and publication of application 18 months. So within 18 months, the application gets published. PCT signed by India. We were the members from 1998, December 7, 1998. At that time, there were 184 countries. Now there are 184 countries. So you can see the India, we are also one of the members of the PCT, International Patent. Once you go to this website, http www.wipo.int PCT. If you want English, type English. You can get all the information about the PCT. You can get all the tutorials, information, filing procedures, presentations. You can download all the information from this website. So this website is very exhaustive website. You can get all the information from this website. So growth of PCT has involved, this is a slightly old slide, since 1996 to till 2022, it has been evolved and there are several countries, they are the members of the PCT. And you can see the PCT filing, it has gone from 1978 is very little, but now it has gone up and consistently increasing over the years. Okay. PCT filing forecast at that time, it was suggested and accordingly it is moving. So this is a toolkit. How does the PCT application goes? 0 to 30 months. Okay. This is a local PCT application filing. That means typically a national patent application in the home country of the applicant has been filed. Before filing the PCT application, you have to file the Indian patent application. Unless and until you don't file the Indian patent application, you cannot file the PCT application. Then in the 12 months, file PCT application, typically filed in the same national phase office, one set of fees, one language, one set of formality requirements and legal. Then 16 months, it goes report on the states of the art, that is prior art documents and their relevance, initial patentability application. Then 18 months, it goes for the international publication. Okay. Then disclosing to the world content of application in a standardized way. Then 22 months, request an additional patentability analysis on the basis of the amended applications. Then at the end of 28 months, additional patentability analysis designed to assist international phase decision making. And at the end of 30, that is enter the national phase, express intentions and take steps to pursue to grant on the various states. So these are the steps involved in the patent application filing. 12 months. So there are several advantages. This postpones the major costs associated with internationalizing. You don't have to pay the fees in each country. It's a one-time fees. Once you have paid, then your application gets filed in several countries. Provides a strong basis for patenting decisions. Harmonizes formal requirements. Then protects application from certain inadvertent errors. Evolved to meet user needs. Is used by the world's major corporations, universities, and research institutions when they seek the international patent application. So there are several advantages of PCT. There are several challenges also while filing the PCT applications. Okay, you have to work on this patent draft or the patent queries raised by the examiner, and you have to give the reply within the certain period of time. Why to use the PCT and what are the advantages? As I discussed most of the themes, basically it brings the world within reach, postpones the major costs associated with international patent application, provides a strong basis for patent decisions, is issued by the world major corporations, universities, and all those things. Then, then brings the world within reach, PCT application, legal effect of regular national patent application in all PCT states. Then you can save the cost, okay, in different currencies. You have to pay only one-time fees. Then legal initial cost, translation or application of patents. Then official fees for the payment, national and the regional patent office. Then fees for the services. Then when these costs are incurred, PCT applicants generally pay 3 types of fees. These are the an international filing fee, then a search fee, and then a small translational fee. These are different fees you have to pay. So these are the toolkits, as I told you, how this goes from the 0 month to about 30 months. Okay. Once it is filed, then you can get the international search report. and the written opinion of the International Searching Authority. Okay, and then you have to reply to these. And then once it is replied, then you can get such type of report from the patent office. They will highlight the queries regarding your patent application, PCT application, and you have to work on this. Okay, these are some of the symbols which are aspect of the patentability analysis. These are the documents relevant to whether or not your invention may be patentable. And this is the claim numbers where the application to which document is relevant. So you have to reply to these queries within a certain period of time. Okay, then your application gets published. So there are some of the statistics which I have shown here, how the patent, who are the countries. Okay, initially they were leading in filing these patent applications. Okay, starting from USA and all others. These are the different companies who are aggressive. Mostly you can see these Korean companies, they are very aggressive, Korean and the Japanese. They are aggressive in the PCT filing. Okay, these are basically top Korean companies: LG Electronics, LG Chemicals, LG Norec, Samsung, ETRI, Seoul National University, then Pohang Iron and Steel Company, then Amor Pacific and Corporation, then Korea Institute of Science and Technology. Then apply secularly online. Once you file this, you can get such type of electronic filing reports on your PCT applications. There is a toolkit or there is a software. Once you apply through this, you can download this type of queries which are raised by the examiners. These are some of the fees: 100 Swiss franc for paper filing, 100 Swiss francs for electronic filing, 200 Swiss francs for electronic filing, then 300 Swiss francs for the electronic filing. Different types. These are some of the forecasts of the e-filings in PCT developments. There are some of the recent developments in the PCT. There are some changes in the rules and regulations. These are some of the PCT applications, okay, which are filing by the different countries. Okay, you can see here different countries and their forecast. This is how this has been filed and this has been increased. Then international applications received. Top is the US, then Japan, and in other countries. There are some of the aggressive companies who are aggressive in filing these patents, mostly the Korean and the Japanese companies. These are some of the universities who are aggressive internationally in filing the PCT applications. And I am very happy to share here that where I have worked, CSIR, Council of Scientific and Industrial Research, where there are about 46 laboratories, under which National Chemical Laboratory is one of them. I work with them, and CSIR is also one of the member who is very aggressive in filing the international patent applications. So once you file the PCT, you get such type of report from the patent attorney, and you have to work on that and you have to give to the reply to the queries. These are the queries raised by the patent examiner. Okay. Then I will come to the last part of it, that is Budapest Treaty. India signed this treaty on 17 December 2001. This is basically about deposition of microorganisms of the purpose of the patent, made available to public after the grant. International recognized depository. We are having a CSIR lab, Chandigarh, that is IMTech, Chandigarh, where you can deposit your microorganisms and then you can go for the further patenting. So IPR licensing and transfer of technology is very, very important. Once you file or get some patents, the licensing is very, very important. Once you license, then you can earn whatever the money you put for doing that research or developing that product. Okay. That is very important. And friends, I'm very happy to share that CSIR is one of the organizations we are earning very heavily from the milestones, okay, and payments and the royalty by selling our intellectual property to the different countries and to the different companies. So once you file the PCT application, you get such type of, once it is published, this is the first page of the PCT application. And you can see that these are the countries where your application get filed. This is the title of your invention, and this is the abstract of your invention. Then once you file your application in the United States, that is US patent, this is the first page of the US patent. Okay, you can see the title, you can see the patent number and date. You can, who is the assignee, you can see the title and name of the authors. Okay, name of the inventors. Okay, you can see the name of the inventors and their affiliation. Once you file the European patent, this is the first page of the European patent. Similarly, you can see the title of the invention, you can see the abstract, you can see the name of the inventors and their affiliation. This is the Korean patent. On the same, we can, once you file the Korean patent, you can get this to your patent in the Korean language. This is our first page of the Indian patent. Same, the application number, then filing date, publication date, who is the assignee and who are the authors. Okay, like this you will get it. And I will come to the last slide of my patent. Youngest patent holder in India. Okay, who is this person? Is Hardwar Singh Bhatti, whose age is 9 years. On September 3, 2000, in the city of Jaipur, he has developed a 6-player variant for chess. He has developed this variant for the chess where 6 players at a time can play the chess. Okay, and he got the patent for this invention. So if you are interested to read whatever today I have delivered, you can go to this website, okay, and you can read this information in detail if you are interested. You can go to the WIPO site, you can go to the patent office, you can go to the USPTO, or you can go to the other patent office. And you can read all the tutorials, information given on this website if you are interested to become an inventor, okay. And to go further, still if you are interested to become a patent agent, okay, if you are having a PhD degree and if you are interested to start your own business, then you can appear for the patent agent examination. This examination is conducted by the Government of India every year, 2 times in a year. So this is the book. Once you go through this book, read this book, all the questions, okay, will be asked from this book, and then you can become a patent agent. Okay, once you become a patent agent, then you can start your own business. That is the additional income you can start along with your regular profession. Then lastly, I wish to acknowledge to all my students, okay, who have worked with me, okay, we have produced several patents, which because of which I could able to license this patent to different companies. And then my colleagues, collaborators from the different divisions, especially and important is the source of funding is very, very important. I got always sufficient funding from the Government of India and my foreign collaborators. Okay, so there was never any shortage of funding for my research. And all, lastly, I wish to acknowledge my sincere thanks to all my directors, okay, with whom I have worked till my retirement. Okay, I am very much thankful to them, okay, for their encouragement, support, okay, during my journey of research about 40 years. And this is my prestigious laboratory where I worked about 4 decades of my life, okay, and because of which I could able to give the today's presentation based on my experience, which I got from this great laboratory, National Chemical Laboratory located in Pune. And thank you very much for your patient hearing. Thank you once again for your kind invitation to deliver my talk and share my knowledge and experience in the field of intellectual property rights. If you have any questions or queries, I will be happy to answer.
Thank you, sir. If anyone having the question, please raise your hand by clicking more option. There is the raise hand option. If you can raise the hand, I will unmute you. Is anyone having the question? Okay, Sutar Gaurav, just a minute. Sutar Gaurav. Sutar Gaurav. Please unmute yourself.
Sutar Gaurav. You want to ask the question? Okay. Sir, thank you. Thank you for the nice presentation. First upon, I apologize for the disturbance which is you have faced during your presentation, because that controls are not in our hands, but we will take the precaution in our further lectures. So in your presentation, sir has explained us what is IPR, what is TRIPS, trademarks related, and also the IP evolution. In that, if we have the idea and if we want to express the idea, for that purpose we have the copyrights as a rights. Again, if we have the idea and if it is innovative, so at that time there is the patent rights. If we have the idea, if we want to keep it confidential, at that time there is the trade secrets rights. If we have idea about the quality and quantity, at that time there is the rights trademarks. Also, sir has explained about IP portfolio, intangible properties and tangible properties of IP. Then why IP protection is essential, various IP international conventions, responsibility of WIPO. Also, sir has detailed explained about trademark, copyrights, geographical indication, GI registration, trade secrets, product patents in India, and also about the what is patent, what is patentable, steps to be taken before drafting the patent, what is non-patentable, public domains. Also, sir has discussed about what is infringements, patent filing process, patent cooperation treaty, that is PCT, and at last at the Budapest Treaty. So thank you, sir. Thank you for your nice presentation. I request Mr. Sachin Khosre, sir, to give the vote of thanks. Mr. Sachin Khosre, sir.
Good afternoon, everyone. I am Sachin Khosre. Pleasure to deliver the vote of thanks for this event on the behalf of Organizing Committee, Department of Chemistry and IQSC, Ramakrishna Paramahansa Mahavidyalaya, Osmanabad. Firstly, I am thankful to the President of today's function, our Principal, Dr. Jaisingh Rao Deshmukh sir, for giving us permission and encouragement to organize such events in our college. We are grateful to our today's guest, Dr. Bhaskar Reddy sir, scientist, Polymer Science and Chemical Engineering Division, CSIR, National Chemical Laboratory, Pune, who despite his busy schedule has found time to grace this event with his amazing lecture. He has really enlightened us by his knowledge, which will be very fruitful for the students as well as budding researchers. So thank you once again, Dr. Bhaskar Reddy sir, for this lecture. My special gratitude to the head of department, Dr. Sunil Jadhav sir, Dr. C. Madik sir, Dr. Sandeep Deshmukh sir, Mr. Mangesh Bhosle sir, Dr. Sambhaji Dhumal sir, and Dr. Radhakrishnan Sutar sir for their cooperation and support to make this event successful. Last but not least, my heartfelt thanks to each and everyone who worked really hard to make this event happen. Once again, I thank you all of your kind attention and support. Thank you so much. With the permission of today's president, I declare here that
Just 1 minute.
event.
Just one, sir.
There is one
Suraj Malik.
question. There is one question from Suraj. Okay, sir.
Okay,
Does
sir.
we
Yes, sir.
can thus we can patent the creative ideas. Okay, so we can patent the ideas provided you have to prove that the idea works with some experimental examples within a certain period of time. But just to get the claim, okay, you can write a patent idea and that protect it based on the date, because if somebody is copying your idea, then the claim goes to the person or goes to the inventor who has filed the idea first. Okay, so you file the idea, but you have to prove that the idea works with certain examples. Okay, then only you can get the patent. If somebody has asked the question, sir, can we file the patent idea? Okay.
Okay, sir. Thank you. Anyone having any questions? Okay, no, sir. Thank you, sir. Thank you once again.
Okay, thank you once again for your invitation and for your patient listening.